Hello, and in my previous video, in Introduction to Actus Reus, we were having a look at the different types of actus reus, i.e. the actual action of the crime, not the guilty mind intention as with mens rea. So you have conduct crimes, consequence crimes, and circumstance crimes. And then we moved on to the general rule that in England and Wales, you can only be liable for an action that you do, a criminal action, and not an omission. And an omission is a failure to act in a particular way. However, there is an exception that you can be liable for certain kinds of omissions. So the first one is if you have a duty situation where you are in a duty relationship with another person, then failing to act, i.e. an omission, you can be liable for. And also you have things called status offences. So these are where this relates to where you're actually being something as opposed to doing something, which is what makes you criminally liable. And the third type is continuing acts, where you may have acted at a different time to when your intentional mens rea kicked in. So you're failing to act at the same time as your mens rea, but you're still liable because we have a situation of a continuing act. So these are the three types of omissions, the exceptions that you can be liable for. So what I want to do in this video is quickly go over the 6 types of duty situations that exist that can make one criminally liable for an omission. And then in my next video, we'll quickly look at status offences and continuing acts. So let's begin. There are 6 types of duty situations I want to talk about. The first one is statutory duty. So an example of this can be found in Section 1 and 2A of the Children and Young Person Act 1933. Where basically it creates a duty for anyone in care of a young person or child under the age of 16 years. So if you fail to act in a way in which would protect and help a young person under the age of 16 and they're in your care, you can be criminally liable for failing to act, even though the general principle states you can only be liable for acts, not omissions. Pretty straightforward, and that would be found in various statutes and is a statutory duty. The second type of duty that exists is a contractual duty. So the key case for this is R. and Pitwood, 1902. Essentially, what we're saying here is that sometimes if you have a contract with another person, if you fail to act as per that contract, you can be found criminally liable in certain situations. So in this case, the defendant had a duty to his employer under a contract to close the level crossing. However, what happened is one day he forgot to do so and went to lunch, and a guy with a horse and cart came along and he died as a result of a train running him over. And the defendant was held liable for this guy's death on the basis that he had a duty situation, therefore failing to act, failing to close the level crossing did create a criminal omission out of the contractual duty that exists between him and his employer. So then the third type of duty is duties in public office. So we're now looking at people who are in public office in government and have a special responsibility. The key case on this is Ditham, 1979. What happened in this case is the defendant was a police constable who witnessed a man being beaten up and died, but he didn't do anything. He failed to act because he had like 3 minutes left or something on his shift. But he was still charged with I think it was he died, so it would have been a homicide of this guy. He was still charged with it because he failed to act in preventing it, because he had a special duty by being in public office. The fourth one, now when we were talking about the 4th, 5th and 6th one, now like what you have to understand is these 6 duties, they're not in clear-cut boxes, so there tends to be some overlap. So now when I'm talking about number 4, which is a voluntary assumption of duty, you may see overlap with statutory duty. So keep that in mind. So voluntary assumption of duty. This is where you assume responsibility of the victim, and it's to do with the nature of the relationship, so the facts of the relationship, and therefore if you don't act in a particular way, you can be found liable. So let's look at some cases. In our incident 1893, the defendant lived with her auntie for 10 years, and her auntie, provided for her. But eventually her auntie caught a disease which made her bedridden, and the defendant continued her normal routine, but she didn't bring, like, for example, the groceries and serve it to the auntie or anything, which made the auntie starve and die. So the court said that her omission, i.e. failing to care and feed the auntie, could be made liable because she had voluntarily assumed a duty by being in such a relationship. And there the judge discusses that this is a way of legalizing moral obligations, basically. So it's kind of a fuzzy boundary, and it depends on the nature of the case concerned. Another case is Gibbons and Proctor. This is where Gibbon and his mistress were taking care of the 7-year-old child. However, the 7-year-old child was left to starve and die, and clearly, the mistress was a moving force in this, and the court held she could be liable for omission to feed because she had assumed voluntary duty by being the mistress and taking on the child in the first place. And similarly, in the last case, looking at voluntary assumption of duty in Stone and Dobinson, this is where a man and his mistress, they both actually were below mental capacity. They were found liable for the man's sister's death because they failed to provide medical help. Now, this was a key case because clearly these two people, they had mental issues, but on top of it, they did try and phone, but they couldn't work out how to use a telephone. And the key point with this case is, had they not tried to interfere, they wouldn't have voluntarily assumed duty. But because they intervened, they had assumed that duty, and in failing to provide adequate care, they were found liable for the sister's death. So you can see some of these cases are pretty harsh. The next case is to do with special relationship. So there are certain relationships, like, for example, the parent-child relationship, which, as you saw with statutory duty, have been put into statute, that will, regardless, bring about a duty, which means you can be liable for omissions. So this can be seen in the case of R. and Lowe, 1973. The appellant's child died from neglect. The trial judge directed the jury that they found him guilty of an offence of neglect, and then he would also be guilty for manslaughter. But it was held you need to act for willful manslaughter, thus it could not be committed as an omission, and it wasn't found. But it was the idea that a duty did exist between the parent and child. Then you have the sixth duty situation, which is the creation of a dangerous situation. So this is basically where somebody creates a dangerous situation and then they fail to act. The omission is what causes the harm. So in the case of Miller, 1893, this guy, he was burning a cigarette and he fell asleep, and he woke up and he saw that this cigarette had caused a fire. But it was so he created the dangerous situation, but then he failed to act, i.e. as in calling emergency services or trying to dismiss the fire, because he simply moved to the other room and fell asleep. And that omission could be made liable because he had created a dangerous situation. So it's more to do with the defendant's previous acts than any duty situation. Similarly, in the case of DPP and Santana Bermudez, 2003, the defendant injured a woman police officer by allowing her to search him, knowing that he had needles, which in turn stabbed her. So basically, again here, the guy, he created the dangerous situation by having the needles and allowing the police officer to search him, but he omitted, as in he failed to inform the police officer or remove them, and that failure could be held liable because he is the one who created the situation in the first place. And similarly, in R. and Evans 2009, the defendant gave her half-sister heroin. The sister injected it, overdosed and died. The court held this was the creation of a dangerous situation. So although she omitted to act, as in failing to stop the sister from overdosing, she was still held liable because in the first place she brought the heroin and gave it. It was her previous record. So this is like the duty situation plus the creation of a dangerous situation, which isn't a duty in so much as it's looking at the defendant's prior acts. And this is where omissions can be held criminally liable. There are two more types of omissions, as I mentioned at the beginning: status offences and continuing acts. And we'll have a look at those in my next video. Thank you for watching.